As a supervisor, you are responsible to make sure that applicants and employees are treated fairly and respectfully, including avoiding, preventing, and stopping all harassment and discrimination. Federal and state laws, including the Age Discrimination in Employment Act, or ADEA, the Equal Pay Act, the Genetic Information Non-Discrimination Act, or GINA, Title VII of the Civil Rights Act of 1964, and Utah Code 34A-5 prohibit discrimination and harassment on the basis of race, color, religion, sex, national origin, and age in any aspect of employment. Any aspect of employment includes hiring and firing, compensation, assignment or classification of employees, transfer, promotion, layoff or recall, job advertisements, recruitment, testing, use of company facilities, training and apprenticeship programs, fringe benefits, pay, retirement plans, and disability leave or other terms and conditions of employment. Discrimination is broadly defined, and not all forms of discrimination can be covered here, but generally it includes making any employment decision based on race, color, religion, sex, national origin, and age, including making assumptions based on stereotypes, abilities, traits, or the performance of individuals based on those categories. Discriminatory practices also include retaliation against an individual for complaining about or opposing discrimination or harassment, filing a charge of discrimination or harassment, or participating in an employment discrimination investigation or legal proceeding. Harassment is broadly defined, and not all forms of harassment can be covered here, but generally it includes any offensive, demeaning, or derogatory remark or slur about a person's age, or an older person's abilities, a person's or their family member's genetic information, a person's national origin, accent, or ethnicity, a person's race or color, a person's religion or religious beliefs or practices, or a person's sex, sexual orientation, or gender identity. Although the law doesn't prohibit simple teasing, offhand comments, or isolated incidents that aren't serious, harassment is illegal when it is so frequent or severe that it creates a hostile or offensive work environment, or when it results in an adverse employment action. It may be difficult to determine when behavior crosses over into harassment, because so much depends on the perception of the victim. It doesn't take into account the intent of the behavior. It occurs when the behavior is unwelcome by the victim. The ADEA prohibits discrimination against people who are age 40 or older. All employment decisions must be based upon an applicant's or employee's competency and performance, not their age. Under the Equal Pay Act, men and women in the same workplace must be given equal pay for equal work. Equal work doesn't mean that the jobs are identical, but they must be substantially equal. All forms of pay are covered by this act. GINA applies to applicants, employees, and their family members. Genetic information includes information about genetic tests, diseases or disorders, fetuses, and requests for receipt of genetic services, including information about an embryo legally held using assisted reproductive technology. An employer may not generally collect, use, or disclose genetic information. If an employee voluntarily discloses genetic information, it does not violate GINA. However, if an employee voluntarily discloses genetic information, or it is obtained lawfully by the city, the genetic information generally must be kept confidential. Under very limited circumstances, genetic information may be disclosed lawfully, but check with Human Resources or the City Attorney's Office before ever disclosing the information. National origin includes birthplace, ancestry, culture, accent, and linguistic characteristics common to a specific ethnic group. National origin discrimination may involve treating people unfavorably because they are associated with a person of a certain national origin or because they have a connection to an ethnic organization or group. A rule requiring employees to speak only English at all times in the workplace is generally considered to violate Title VII. However, an English-only rule can be adopted if it is 1. Justified by business necessity, and 2. Narrowly tailored to address the business necessity, for example, if it is necessary to perform the job effectively and safely. If adopted, the employer must inform its affected employees of the general circumstances when speaking only in English is required, and the consequences of violating the rule. Before adopting an English-only rule, consult with human resources. An employer may not base an employment decision on a person's foreign accent unless the accent seriously interferes with the person's job performance. Race discrimination involves treating a person unfavorably because of the following. The person is of a certain race. The person has personal characteristics associated with race, like hair texture, skin color, or facial features. Or the person has an association with a person of a certain race or color, or an association with a race-based organization or group, or an organization or group that is generally associated with people of a certain race or color. Color discrimination involves treating a person unfavorably because of the color of their skin or complexion. Title VII protects people who belong to traditional organized religions, people who don't belong to traditional organized religions but have sincerely held religious, ethical, or moral beliefs, and those without beliefs. Religious discrimination can include treating a person unfavorably because they are associated with a person of a particular religion or religious group, and forcing a person to participate or not participate in a religious activity as a condition of employment. Title VII requires an employer to reasonably accommodate an employee's religious beliefs or practices, meaning that they must make reasonable adjustments to the work environment to allow the employee to practice their religion or beliefs. Examples of accommodations include flexible scheduling, voluntary shift substitutions or swaps, job reassignments, and modification to workplace policies or practices, including dress or grooming policies. However, if an accommodation would cause an undue hardship, it does not have to be granted. Factors that cause or create undue hardship include excessive costs, workplace safety or efficiency, infringing on the rights of other employees, or unduly imposing additional hazardous or burdensome work on other employees. If an employee requests a religious accommodation, please consult with Human Resources or the City Attorney's Office. Sex-based discrimination and harassment is broadly defined, and not all examples of sex-based discrimination and harassment can be covered here. Note that victim and harasser can be either a woman or a man, and the victim and harasser can be the same sex. Sex-based discrimination can include treating a person unfavorably because of the person's sex and because of their association with an organization or group that is generally associated with people of a certain sex. Sex-based harassment can include unwelcome sexual advances, requests for sexual favors, verbal or physical harassment of a sexual nature, workplace conditions creating a hostile work environment, or offensive remarks about a person's sex in general. For specific examples of sexually offensive language and conduct, see page 23 of the Supervisor Guidebook. Sex-based discrimination and harassment also encompasses discrimination against a woman because of pregnancy, childbirth, or a medical condition related to pregnancy or childbirth. The inability to perform a person's job due to a medical condition related to pregnancy or childbirth is treated like any other employee with a temporary disability, such as modifying tasks, making alternative assignments, or granting disability leave or other unpaid leave. Pregnant employees can consult with Human Resources about FMLA and disability benefits. As a supervisor, you are responsible for understanding, observing, modeling, and training. Understanding. Become familiar with the city policy regarding discrimination and harassment, including the city's Equal Employment Opportunity and Unlawful Treatment Policy in the Employee Handbook on pages 4 and 5. If an employee comes to you with a concern, address it immediately. See the section titled Responding to Employee Complaints on pages 24 and 25 of the Supervisor Guidebook, and the Complaint Resolution Procedure on page 55 of the Employee Handbook. If you don't feel comfortable addressing the concern, refer the employee to the resources listed in the Complaint Resolution Procedure. Observe. Do not distance yourself from the work environment. Know what is going on in your workplace. Model. Be an example to your employees of appropriate behavior at all times. Training. In addition to the periodic training from Human Resources, you should do the following. Regularly instruct your employees on discrimination and harassment. Show your employees that you take discrimination and harassment seriously and that you expect them to do the same. Don't let minor incidents slide by. Address inappropriate behavior when it first occurs. And use one-on-one situations as a chance to train employees on appropriate and inappropriate behavior in the workplace. You are responsible to understand this complete section. Please take the time to read over it in the Supervisor Guidebook. Please contact Human Resources with any questions.